behalf of George Allan Kelly, he is present.
Yeah, we need to check the fingerprints. Whenever anyone's comes before the Superior Court, we check their fingerprints, 2 of their prints, just to make sure we have a full set of prints on file.
George Allan Kelly has just entered the room, and he's getting his fingerprints checked, walked right on in there, and right up to the podium. His attorney standing at the podium, presuming that is Brenna Larkin.
Good afternoon, sir. Is your true name and your complete name George Allan Kelly?
Yes, Your Honor.
Could you please tell me your date of birth?
1/27/1949.
The reason you're here with your attorney is this is the Superior Court. A document's been filed called an information. This is the piece of paper that states the charges against you, and it's the piece of paper that gets the case moving forward here in the Superior Court.
We just
These
read
are
that.
charges only. You are presumed innocent of the charges. You have the right to have a trial on the charges, and the trial would be to a jury. Because you're presumed innocent, the prosecutors have what's called the burden of proof. They would have to bring in witnesses and testimony and evidence to persuade the jurors that you're guilty, and in order to do that, they'd have to meet a very high standard of proof. It's the highest we have in our legal system, and that's called proof beyond a reasonable doubt. You have the right to have an attorney represent you, and if you cannot afford one, the court will appoint one to represent you. We've already done that in the Justice Court. You have an attorney, Ms. Brenna Larkin. She defends you. She has the right at the trial to cross-examine and question the state's witnesses and to challenge everything they try to prove. She has a right to present a defense on your behalf and to call witnesses to testify in your defense. And if you have a witness or witnesses who will not voluntarily come into court, your lawyer has a way of compelling and making those witnesses come to court and testify in your defense. At the trial, you'd have the right to testify also in your defense. You'd also have the right to remain silent and to not testify. And if you chose not to testify, the judge would instruct the jurors that they could not hold that against you. That's because you have what's called a privilege against self-incrimination. You're also required to be present for all your court appearances, and you have the right to be present for all your court appearances. Should you fail to appear for court without good reason, the case could go forward without you. And we haven't set a trial date, obviously, yet, but you are required to be here for your trial. Should you fail to appear for your trial, the case could go forward to trial in your absence. Ms. Larkin, do you waive a formal reading of the information and enter a not guilty, please?
Yes, Your Honor.
Thank you. Does the state have the Rule 8 out-of-custody time limits?
September 2nd of 2023, Your Honor.
That's the way I figured it, too. What I'm going to do in this particular case is I'm going to set this matter for trial. I'm going to set it for September 6th, Wednesday, September 6th, 2023.
That's my birthday.
The time limits expire on Saturday, September 2nd. As I said, that's a Saturday. Then Sunday's the 3rd. Monday is Labor Day, so the court will be closed. The 5th will have to be our law and motion calendar and the way we're doing this today. So we'll set trial with the jury before this court for Wednesday, September 6, 2023, beginning at 8:30 in the morning. We'll set it for Wednesday, the 6th, 7th, and 8th, and then recommencing on Tuesday, the 12th, 13th, 14th, and 15th. And we'll go the next week, the 19th through the 22nd, if needed. We'll make jury instructions and voir dire filed jointly at the same time for due on Friday, August 18th. And we're going to make dispositive motions due on Friday, June 30th, 2023. I'm not going to set any other hearings at this time. If the defendant and the state arrive at a proposed plea agreement and you wish to present it to the court, file a notice and the court will hear it. And if and when the parties are ready to present a Donald hearing, have a Donald hearing, just notify the court and we'll set that promptly.
And can I just make a record, Your Honor?
Yes, ma'am.
We'd be requesting that Your Honor not set this case for trial at this time. We'd be requesting a 60-day continuance so that we can set this for a status hearing. We do have experts that we've engaged. We're hoping to get some forensic evidence taken a look at in this case, hopefully fairly soon. But there is some extensive investigation that we, the defense, have got to accomplish in this case. We also filed a motion for a remand or a review of that preliminary hearing. I understand Your Honor's not going to hear that today, but we just want something on the books so that we perhaps have a deadline when Your Honor will be making a decision on that motion. And it came to my attention today that just today the state executed an additional search warrant out at Mr. Kelly's property.
Oh.
So the state is continuing to collect evidence and pursue an investigation.
Wow.
And we obviously need disclosure of the results of that search warrant and all of that stuff. So for those reasons, we'd be asking to not set this for trial at this time and to give both parties the time to complete the investigation.
I saw the motion for the review of the probable cause hearing before the Justice Court. That's going to require the preparation of transcripts. What I didn't see is a proposed form of order from the defense for the court for the ordering of those transcripts. So as soon as you prepare...
I did file that today, Your Honor.
Great. As soon as I see that, I'll sign it, and the court reporter will get to work on those transcripts. Yes.
And Your Honor, I did not receive Ms. Larkin's motion, so if I could have Ms. Larkin send me a copy of that, I would appreciate it.
All right. But the court
I can do that.
I'm sorry?
And
Yeah.
then, of course, we'll want to have an extension to respond until after the transcripts, 10 days after the transcripts are prepared.
Right. I think that's customary. But we'll see how quickly the transcripts get prepared and then how quickly the court... I can read transcripts quickly, so I don't think that's going to be an extensive decision. But I am going to set keep the case for trial as set at the present time. If extenuating circumstances arise during the course of the proceedings and a continuance, in your opinion, is needed, file the motion. State will have a chance to respond, and we'll hear the motion. So now we set a trial date, Mr. Kelly. At the present time, it's September 6, 2023. As I said before, you're required to be here for your trial. If you fail to appear for your trial without good reason, the case could go forward to trial in your absence. Do you understand all of that?
Yes, Your Honor.
Do you have any questions, sir, about what I've said so far?
No, Your Honor.
Very well. I'm sure you'll stay in close contact with your attorney, Ms. Larkin. She's got a lot of work to do. I've set a trial date. A lot of that work she has to do with you. So I'm sure you'll make yourself accessible to her so that you can participate in the preparation of your defense.
Yes, I will, Your Honor.
Very well, sir. Anything else, Ms. Larkin?
No, Your Honor.
Ms. Hunley?
No, Your Honor, thank you.
Your
Honor, we haven't received a response, therefore, suspect
All right. Did you get a full set of fingerprints taken, sir, when you were arrested, if you remember?
As far as I remember, yes.
I'm pretty sure you did, but we'll check on that. I'm not going to order anything additionally at this time because I'm confident you did, but if I turn out to be wrong, then we can take care of it. But thank you. All right, you're excused. Thank you.
May I be excused, Your Honor?
Thank you.
Your Honor, may I be excused as well?
Yes.
Thank you.
That's the prosecutor speaking over there.
Case versus Reynaldo Bautista Sandoval, 21-146.
So that was Kim Hunley, the
Beverly Hines for the state.
chief deputy assistant prosecutor, who is also being excused. Very short arraignment, about what we expected. Nothing too unusual there. We did get some dates that we added over to the mind map. Of course, the mind map is available if you're a member. If you're a member on Locals or a member on YouTube, then you can grab the link for it. Of course, we added these down here. The trial will be September 6th. Holy moly, what a great day for a trial, isn't it? And it is also, we got some additional deadlines coming up, August 18th, Friday, June 30th, for more motions and pretrial filings. Now, the reason, trial is far away, right? There's no question about that. And trial may not actually happen on 9/6. Remember that in criminal cases, we have you have a right to a speedy trial. And so when you have a complex case like this, a case that's designated complex with murder and all sorts of different forensics and many different witnesses and many different victims and so on, all in this case, it doesn't surprise me that the judge pushed it out that far, and it may get pushed back again. We'll see. But it depends on who's asking for the continuances and who's asking for the extensions. So in this case, right, let's say, Brenna Larkin has an issue with an expert witness. Somebody's got a conflict. She needs this really great expert who's going to come in and testify about the border war, and he's not available on 9/6. So she says, well, he's not available on 9/6, but can we do it on October 6th? Well, if they push it back into October, those 30 days wouldn't count against George Allan Kelly, right? So she would sort of waive that time, and the trial could be, pushed back. And oftentimes they are. I actually wouldn't expect this case to go to trial in September. However, for George Allan Kelly's sake, I hope he does get some closure sooner rather than later. Now, the other thing you heard from Brenna Larkin was asking about a status conference, because of course she filed the motion for sort of a review of the magistrate's probable cause, which we will get back to in a minute. And she wanted to sort of say, let's put an anchor in that so that we can come and address that, because really she doesn't want this case to go forward at all. She's trying to get this thing knocked back down out of the Superior Court, back down into the Justice Court, so that the Justice Court, maybe has a remand to go and try it again, right? Try to find probable cause another way, because it's not justified right now. We've got victims that have differentiating stories from one another. We've got, lacking forensic evidence and all sorts of other things that made this feel like a pretty weak case back then. Send it back down. The judge said, I'm not going to think about that right now. It's going to require transcripts. It's going to require a proposed form of order. It's going to require a response from the prosecutors, right? It's going to require a reply. So he wasn't going to hear any of it today. You also heard him talk about a Donald advisement. This is a phrase that we use in Arizona. It's referencing a case where the government will extend a plea offer in any criminal case. They don't have to, but they typically will. And so they'll come back to George Allan Kelly and they'll say, okay, you're going to plead guilty to murder. We'll dismiss the other 2 aggravated assault charges. We'll ask for, 15 years or whatever. And, which would basically, I guess be a death penalty for him, whatever it is. I'm sure he's, wouldn't do exactly well in a hardened prison for murderers at 73 years old, but you get the point. So the Donald advisement, when the government does make that offer, that plea deal offer, this would be an opportunity for the judge to explain to the defendant. So in other words, George Allan Kelly would be sitting there in court and the judge would say, all right, here's what you've been charged with. Here's what happens if you go to trial. This is what the statute says. I can give you up to this amount of time. I can give you the minimum this amount of time. Here's what the plea deal says in relation to that. And these are these can be very useful as a defense attorney. These can be instructive to the defendant. Because a defendant might be sitting there. You might say, look, man, I've got this plea deal for you. It's a 2-year plea deal or it's a 5-year plea deal. If you go to trial and lose, the minimum that you get is 15 years or 25 years because these charges all stack on top of one another. Does that make sense? He says, yeah, it makes sense. And so he says, I still want to go to trial. Something that you might want to do, right, is have a Donald advisement so that you can have a conversation about this so the judge can explain it so that they know sort of what the risks are if they do take the case to trial. It can be very useful from a defense perspective. It also can be very scary and infringing upon the defendant, right? I've seen, I think, defense attorneys use this to scare people and bully people into plea deals by encouraging them to take deals that maybe they shouldn't have taken. I'm not saying maybe not that strongly, but it is, right? It can really scare somebody to say, if you have a weak case, this is what you face at trial. And so we're trying to avoid that. So this is still very early, not really any new surprises. We did learn there was a surprise. 3rd search warrant got entered today. They just learned about that today. So we have a new amended complaint. We have a new search warrant, 3rd search warrant. I wonder what they're looking for. Still digging up around it.